All dressed up for nothing, apparently, Judge.
All right, well, Ms. Stamper, whenever
Good
you're
morning,
ready.
Your Honor.
Good
May
morning.
it please the court, Nancy Stamper for State Farm. This is a consolidated case of two petitions for protection from discovery orders. The first discovery order was May 6, 2021. I'd like to reserve 5 minutes. I'm sorry.
I did that for you.
Thank you. The first discovery was May 6, 2021, and the court ordered State Farm to submit to both deposition of its claims representative and written discovery. Later, June 10th, 2021, the court granted State Farm's motion for protection from the deposition, but allowed the discovery to go forward on the lien discovery. It's a strangest case I've ever handled in a very, very long career.
I'm glad you said that because I found it strange myself.
There were two statutory pre-suit demands on State Farm. The first was in the first was in June 19 by Florida Legal Group. Second was in July 19 by Lando Associates. The first statutory pre-suit demand contained no assignment of benefits, no bills, but claimed that it was a notice of lien. However, it was never filed as a lien. Then along came the second statutory pre-suit demand by Attorney Landau and a filed complaint in August of 2020. A huge gap between the demands and the complaint. The Landau lawsuit was settled and was dismissed in December 2020 with prejudice. Florida Legal Group filed its complaint before the dismissal of the Landau suit, but after the service of the Landau suit. They filed their complaint in October of 2020. Discovery ensued, and State Farm ultimately, not right away, and I have no explanation for why, but State Farm ultimately told the Florida Legal Group that the case had been settled by the Landau firm and was dismissed with prejudice. Same provider, same insured, same bills, same everything except the attorneys. So then the discovery started, and State Farm asked for protection.
Ms. Stamper, could I ask you what may be a simple question, but a little bit off the mark? What do you say to the petition being moot by virtue of subsequent pleadings?
If you're talking about the first amended complaint, Your Honor, that was filed later,
Yeah.
first of all, it's not in the record. And second of all, is that it? Is that good?
No, I was just looking for what I would hope is going to be a simple answer for me.
And it doesn't solve the problem because it still doesn't establish that Florida Legal Group has a client. The provider has gotten its money. The provider's happy, apparently. And Florida Legal Group is, for all intents and purposes, out there on its own. And I have probably 5 arguments. First, Florida Legal Group.
They're not a party, correct?
Is not a party. And hasn't proven that it has, it takes an assignment of benefits. There's a very recent case out of the 4th District called the Kidwell Group. And what the 4th DCA said, and this court has said the same thing, it takes an assignment of benefits, first from the insured to the medical provider, and that doesn't exist for Florida Legal Group. It existed in the Landau lawsuit. There was an assignment of benefits and there were bills. There's neither in the Florida Legal Group. Florida Legal Group is out there on its own. In Market Tampa, this court said, this is a stranger to litigation. Florida Legal Group is a stranger to litigation. So for that reason alone, this case should not even exist. But second, the lien was never created. You can't say in the state of Florida, you can't just send somebody a letter and say, this is a lien. This lien was never filed. And there are so many cases from this court and others saying you've got 2 ways to perfect a charging lien attorney. The first is to file it in the initial lawsuit and pursue it in the initial lawsuit. And the second is to file it. That's not been done in this case. At least it wasn't done as of the time that these orders were entered. And I'm not aware of, I know the first amended complaint is out there, but I'm not aware of other post-appeal documents because they're irrelevant to this lawsuit.
And let me just go back to that question that Judge LaRose asked about it being moot. In addition to it not being in the record, these orders haven't been vacated, right? They're still enforceable.
They have not been
Is that
vacated.
correct?
That's correct. That's correct. The first order at this point, is kind of irrelevant because the second order, the first order, the discovery in the first order has been brought into the second order. The depot is stayed, but it's the document discovery. And on that issue, State Farm has raised at least 3 arguments. First of all, this is a claim file. This court has said in Doctors Company, Judge Kelly, that's yours, and Owners Insurance Company, Judge LaRose, yours. You don't get an insurer's claim file until you have proven coverage. And there's no proof of coverage in this case. There's not even proof of a client in this case or a provider. So this is our claim file. Second, we've raised work product and attorney-client, and there's been no in-camera inspection of these documents. So for those reasons, this even in a vanilla lawsuit, and this one is certainly more almond and pistachio, even in a vanilla lawsuit, this discovery should not have taken place. And for that reason alone, we believe that we're entitled to protection. Second, in the first amended complaint, which isn't in the record, but there's still no evidence Florida Legal Group represents the provider. And if it represents the divider on a question of common sense, shouldn't it be getting these documents? Shouldn't it turn to its provider? I have no law on this, and say to the provider, did you get paid? And if you got paid, why didn't we get paid? We were your first attorneys. That's not State Farm's issue at this point. Second, the issue has been raised that we should have filed a privilege log. In Harley Shipbuilders, this court said there's no right to discovery, and so until that determination is made, no privilege log is necessary.
I mean, what argument did they make in the trial court that as a third party, not a party to this litigation, that they had the right to serve discovery?
You know what, Your Honor, I've asked myself that same question, and I think the court said, I don't know what's going on here. Let's find out what's going on here. Here are 2 law firms. I know. But these are 2 law firms, 2 respected law firms, both saying we represent the client. And State Farm said, wait, we paid. Why should we don't have a dog in this fight anymore. And the court said, let's just figure it out.
And what would they have a lien on? And I think you mentioned this in your argument. What lien on what? Because they didn't do anything.
Attorney's fees. We've all seen these cases before. They sue, the providers owed $3.98 and the attorney's fees are $70,000. What's left in this case is attorney's fees for Florida Legal Group. There's no way around that. And if they get their
right, but they didn't lien against what fund, because they didn't recover anything. Right.
They did not recover. They never filed it as a lien. Lien has, first of all, you have to prove that you had a client. Second of all, prove you had a dispute with the client. Third of all, you're owed something from the client. And fourth of all, you file your lien. Not one of those things exists in this case. And all State Farm wants at this point is just not to have to produce its claim file. And the settlement documents, Florida protects settlement documents. Settlement documents can't even be filed with the court unless you have to enforce the settlement. And so, the one case that's been raised by that I thought I needed to distinguish is Brown versus Vermont Mutual Insurance Company. In that case, there was a proven attorney-client relationship that doesn't exist here. The client terminated the attorney. We don't know. The record is silent on what happened between June of 2019 and October of 2020. What happened between this provider and Florida Legal Group? We have no idea. We don't know. And third, the attorney's entitlement to attorney's fees. that doesn't exist in this case. So for those reasons, Your Honor, I respectfully request that you quash this discovery order, protect State Farm from discovery, maybe even order that this lawsuit be dismissed, and I'd like to reserve the rest of my time.
Okay, very good. All right. Mr. Blum?
Thank you so much. The issue here is whether or not this court agrees that the carrier was placed on notice when we sent our notice of lien prior to either lawsuit having been filed.
Well,
I want to get into the substance.
Now, wait, I have a question. You're not a party to this litigation. How do you have the right to serve discovery?
Under the Brown case, the court is very clear. It refers to settlements made without knowledge of or notice to a party's attorney. We have a contract. The contract with the provider is what gives us lien rights. When we sent the pre-suit demand,
No, I didn't ask about
therein,
lien rights. I asked you, as a non-party to this litigation, how is it that you have the right to serve discovery?
we rely on Brown. We
Okay,
rely on Brown that says any settlement made without knowledge of or notice to a party's attorney and without payment of the attorney's fee due such attorney operates as a fraud upon the attorney, whether intended or not, and the attorney may continue the litigation in the name of the parties to enforce the right to be paid a fee in those instances.
but
where the
you
attorney
didn't
is
continue the litigation. You instituted new
No.
litigation.
Well, but we weren't aware. See, State Farm had the obligation to notify us. That's why we include the notice of lien with the pre-suit demand. We did not know about the prior suit filed by Landau. And so that's why the notice of lien is included with the pre-suit demand. We're asserting a claim. And what the court and what my colleague have discussed so far is
2 seconds left.
Okay. What I would say in the limited time that I have is where fees are awardable from an insurance company pursuant to a statute like 627.428 in the underlying case. An insurance company is not relieved of its obligation to pay a statutory attorney's fee just because it's settled with the plaintiff. In fact, the insurance company remains jointly and severally liable for attorney's fees and costs. Thus, in this case where the defendant failed to protect the lien of FL Legal Group, it is liable to the firm for those fees and costs. And I'm referencing Geico General Insurance v. Steinger. It's 275 Southern 3rd 775. It's a 3rd DCA case from 2019. In this case, the carrier was on notice of our lien rights. It ignored our lien rights. It settled with Landau and Associates. We are maintaining the same lawsuit we filed as a result of the carrier not informing us that there had been a competing claim for those benefits, because otherwise we would have filed the charging lien in that first filed lawsuit. We're entitled to do so under the Brown case.
Mr. Blum,
yes.
I'm sorry to interrupt, but I want to just ask you, where we are is we're reviewing these orders and what was in the record at the time the trial court entered these particular orders, which have not been vacated. They're still enforceable. And what was available to the trial court at that time, which was a lawsuit for benefits under an automobile insurance policy, a breach of contract lawsuit that said nothing about lien rights. So I understand you've amended it, but we aren't there. We have to look at what the trial court had available at the time these orders were entered. So looking at it from that point, what would have justified these orders at that point in time?
The orders are justified as a result of the lower tribunal's understanding of what Brown v. Vermont Insurance stands for, which is when our lien rights, meaning the law firm's lien rights, are violated, we can maintain the lawsuit that we filed to pursue our lien rights. We can do so without amendment.
But you
The
did,
amendment
you
came
did not
later.
file, you did not file a lawsuit to make about lien rights
That is
at
correct.
that point,
because
at
we
that
did not-
juncture.
That is correct. That no one is denying that. What happened was we weren't told that our lien rights had been violated, or that the matter for the PIP benefits had been resolved. Once we found that out, we were entitled, and the lower tribunal agreed, to pursue the violation of our lien rights in that lawsuit, that where the complaint,
Okay.
admittedly,
Okay,
was for
I've
PIP
got it.
benefits.
I've got it. I got
Okay.
it. Thank you. I know I asked that question about 5 different times. I think I understand your answer.
You know
now.
what, Judge? I get, you know what, I get the confusion. This is a unique case. And at the end
Yes.
of the day, the court should not allow the carrier to perpetrate this fraud to deny us our fee. We wouldn't have filed the lawsuit had they done its job and met its duty under the rules regulating the Florida bar and tell us, hey, there's a competing claim. You guys sent us this notice of lien. I don't know if you got a lien or not, but you put us on notice of the fact that you are claiming that. So we're in this lawsuit. File your charging lien, and we'll resolve that in this case. They didn't do that. They've done it in others. They didn't do
Okay.
that here.
I understand.
That's why we
I
filed a
understand.
lawsuit.
I understand your argument now. I appreciate you hanging in
Thank
there
you.
with me.
You know what, Judge? It's my pleasure, and you know, I'm sorry if I was in any way confusing.
No, I think this situation's confusing.
It
Okay.
is. It is. And this, with respect to the, if you want me to address some of the arguments that my colleague made, I'm happy
You
to
do not
sort
have
of bullet
time,
point
sir.
that.
You don't have any,
Okay,
you're
okay.
down to 10 seconds, so wrap up.
Okay, well, there's no claim of privilege because there's no privilege law that's been filed. Again,
All
this
right.
is moot because we have an amended complaint. This is moot because we've got a amended complaint. And my colleague's correct. There's no law on this topic. But they were clearly on notice of our lien rights. That they
All
didn't
right.
act on that.
All right, sir. I think we understand your argument now. Thank you very much.
Thank you.
All right, Ms. Stamper, you have 5 minutes for
Thank you, Judge.
rebuttal.
First of all, the amended complaint isn't before the court, but I pulled the amended complaint while we were on hiatus. The amended
Well,
complaint
actually, it actually is in an appendix, but I
is
understand what you're
filed, but it
saying.
wasn't before the trial court.
Right, right.
It alleges a charging lien. So then I go back to all the case, and it does not attach an assignment of benefits. It attaches the same June 18th, 2019 notice of lien letter, demand letter, which is not a lien. As far as Brown, I also pulled that. Brown says a charging lien is an equitable right. There is no other type of lien for recovery of attorney's fees. That is, if they're arguing now equitable lien, then the cases say, well, that's a charging lien. Charging liens go back to filed and perfected in the case in which the relief is sought. The relief is sought in the main case, the provider's case. It also says all that is required to entitle the attorney to perfect a charging lien is for the attorney to file the notice of lien or otherwise pursue the lien in the original action prior to its determination.
Okay, well, but I believe Mr. Blum's point is they didn't know about the original action. They couldn't do that. You had notice, you got their notice of lien. They named the specific individual, the specific dates of treatment, the claim number, et cetera. You had all the information, but you went ahead and you litigated the case, settled it, and they never knew about it. So they didn't have that opportunity. So what's your response to that? What should they do now?
My response is, where was their own client? How come they didn't know all this from their own client? If they still have that client, which they still have not shown, except for Mr. Friedman's affidavit, which, I mean, where is
Well, we do have his affidavit, and apparently they have provided the contingent contract to the court for in-camera review.
we under seal, so we don't know what it says. But you know what?
But really, answer my question really is, you knew about this, you got the notice, and you never contacted them. You never let them know, hey, we're going to do this settlement that you sent us this notice.
I know.
What are they supposed to do now?
Well, let me go back to the fundamentals of one, State Farm. I wish I could tell you how many times that happens with insurance companies, but this is a discovery order. That's all that's before you. I'm sure I'm going to be back on this case, but on this particular issue, there is nothing before the trial court that permitted it to invade our claim files. And that's what this, the only thing before your honor is lien discovery. The trial court hasn't looked at that confidential contract that apparently establishes their right. The discovery is premature. And that's what a petition for cert is designed to do.
Okay, well, let me stop you right there. You said it's premature, which suggests to me that at some point it will be mature.
I know.
So then where's the irreparable harm if ultimately they're entitled to this discovery once everybody gets their ducks in a row?
Because they haven't proved coverage yet. And every single case in the state of Florida, and you know, this one up and down the pike for years.
If it's lien discovery, how does that make a difference?
Because the trial court hasn't even looked at the document that ostensibly establishes their right to lien discovery. That's the document. It's not in the complaint. The first amended complaint has only the same demand letter. It doesn't have anything that shows they have a client and the client assigned them any rights. That's what's missing. It's a missing link. This is putting the cart before the horse. This order should be quashed. It's going to have to be sent back to the trial court because it's still a pending litigation. And the trial court has to unwind who has what rights. And at that point, if the trial court does an in-camera inspection of our files and says, okay, this is not attorney-client, this is not work product, this is not claim file protected, then it may be appropriate, but we're not there. That's why this order should be quashed and everything else needs to be, we kind of got off track because we're talking about the first amended complaint, not before this court. It's in the record.
No, I understand that.
And we're talking about lien rights, but so far, no one has proven a lien. First, he's got to prove he has a lien, and that's got to be done by quashing this order, sending this back to the trial court, and say, take a look at the confidential document. By the way, we should be allowed to look at the confidential document because it's a violation of our due process rights for them to have the contract, not produce it to us, and argue what it says. So there's a lot going on here. The bottom line is this particular order is premature.
Okay, thank you very much. Thank you
Thank
both.
you,
And thank you for coming back and finishing up.
I'm going to have wine.